Hello viewers, today we will be dealing with the constitutional provisions relating to environmental protection. First of all, let us go with the objectives of this program. The objectives are to understand the constitutional provisions relating to environmental law, to understand the role of constitutional remedies towards environmental protection, to understand the evolution of public interest litigation, to understand judicial activism in India. The introduction relating to the constitutional provisions. The Constitution is known as the basic law of the land and rule of law of our country, from which all other laws derive their powers. The then Prime Minister of India, Mrs. Indira Gandhi, was the first head of state to address the first international conference, United Nations Conference on Human Environment, at Stockholm in the year 1972, and voiced deep concern in the aspect of degrading environment and eco imbalances. India was also one of the signatories of the Stockholm Declaration, which is known as the Magna Carta on Human Environment. To fulfill its promise made at the Stockholm Conference, the Indian Parliament passed the 42nd Amendment to the Constitution of India in the year 1976 and incorporated specially 2 articles relating to protection and improvement of the environment, which are Articles 48A and 51A Clause G. Law is a regulator of human conduct and plays a dominant role in protecting the environment from pollution, mainly by regulating human activities. As a common phenomena, most of the environmental problems in every state are generally handled at the legislative level. For example, India has enacted various laws to protect the environment, flora and fauna. The Constitution of India is amongst the few in the world which contains specific provisions for the protection and improvement of the environment. The Supreme Court faced a challenging phase till the development of environmental law in India, and during such time they looked into the constitutional provisions of law, specifically the fundamental rights, duties and judicial remedies for solutions towards severe and growing environmental problems. Now let us deal with the environmental protection and fundamental rights under the Constitution of India. The fundamental rights are the heart of the Indian Constitution, and in absence of specific environmental laws, the fundamental rights enable the citizens to secure justice. Thus, the fundamental rights relating to environment are Article 14, right to equality, Article 19, freedom of speech and expression, right to know and freedom to carry on trade or business. Article 21, right to life and personal liberty and environmental protection. Article 32 and 226, environmental protection and judicial remedies. Article 253 and environmental legislation. Principle 1 of the United Nations Conference on Human Environment, 1972, Stockholm, finds reflection in Articles 14, 19 and 21 of the Constitution of India, dealing with the right to equality, freedom of expression and right to life and personal liberty respectively. All these rights are secured to the people of India under its Constitution, particularly in Part 3 dealing with fundamental rights. These ensure protection of citizens' rights and their dignity by way of judicial remedies. The right to life and right to live in a healthy environment. Article 21 of the Constitution of India guarantees all persons a fundamental right to life and personal liberty. Article 21 guarantees a fundamental right to life, a life of dignity to be lived in a proper environment, free of danger of disease and infection. The talk of fundamental rights, and in particular right to life, would become meaningless if there is no healthy environment. The Indian Supreme Court came out of the shackles of mechanical and rule-bound justice and provided impetus to the expanded horizons of the fundamental right to life and personal liberty guaranteed in Article 21. Two methods are used by Supreme Court to strengthen Article 21 and to interpret unenumerated rights under Article 21. It required laws affecting personal liberty to pass the tests of Article 14 and 19 of the Constitution, thereby ensuring that the procedure depriving a person of his or her personal liberty be fair, reasonable and just. The first formal recognition of the right to a healthy environment came in the Stockholm Declaration, which emerged from the pioneering Global Eco Summit in 1972. Man has the fundamental right to freedom, equality and adequate conditions of life in an environment of a quality that permits a life of dignity and well-being, and he bears a solemn responsibility to protect and improve the environment for present and future generations. Thus emerges the concept of intergenerational equity that says humans hold the natural and cultural environment of the earth in common both with other members of the present generation and with other generations past and future. The onus lies on the state to conserve and use environmental and natural resources and protection of biodiversity also. The state shall also provide access to pre-information, administrative and judicial procedures and explain them the due process of law for those who are to be affected by state planned developmental activities. Right to equality. Article 14 of the Constitution provides, the state shall not deny to any person equality before the law or equal protection of the laws within the territory of India. In fact, the absence of arbitrary power is the first essential of the rule of law upon which our whole constitutional system is based upon. In a system governed by rule of law, discretion when conferred upon executive authorities must be confined within defined limits. All shall have the right to a healthy, balanced environment as well as the duty to defend and conserve it. The right to development should be achieved by equitably meeting the development and environmental needs of the current and future generations, as saving environment amounts to saving ourselves and our biodiversity. Article 14 ensures equality to all, and we observe that some of the decisions related to developmental projects such as construction of dams, power plants are taken without giving due concern to the displacement of people of villages and tribals. If proper rehabilitation is not done to the displaced people, it amounts to violation of Article 14 and Article 21, as the villagers also have an equal right to live. Article 14 and 21 are generally used as weapons by a common man. The onus also lies on industries to ensure that they should not endanger any human being's life, including flora and fauna, by pollution that arises due to manufacturing process taking place in an industry or any other operation of the industry, so that every person can live in a healthy environment. fundamental freedom of speech and expression. Article 19, Clause 1, Clause A guarantees every citizen a freedom of speech and expression. In India, most of the environmental jurisprudence has developed by judicial activism. Most of the cases emerged from the court as a result of public interest litigations in which the people exercise their freedom of speech and expression. Freedom of speech and expression under Article 19, Clause 1, Clause A also includes freedom of press. Public opinion and media has played a major role in creating awareness among the public about various environmental issues in India. In P.A. Jacob versus the Superintendent of Police, Kottayam, the Kerala High Court held that freedom of speech under Article 19, Clause 1, Clause A does not include freedom to use loudspeakers or sound amplifiers. Thus, noise pollution caused by the loudspeakers can be controlled under Article 19, Clause 1, Clause A of the Constitution. Right to know. The right to know is also implicit in Article 19, Clause 1, Clause A and is closely linked with Article 21 of the Constitution, particularly in environmental matters. The right to know or access to information is the basic right which the people of a democratic country like India should be utilizing in the right perspective. Freedom to carry on trade or business. Article 19, Clause 1, Clause G guarantees all citizens the right to practice any profession or to carry on any occupation, trade or business. However, this right of the citizens is also not absolute. It is subject to Article 19, Clause 6 under which reasonable restrictions in the interest of the general public can be imposed. Thus, environment can be protected from the hazardous trade activity. Right to livelihood. The judicial grammar of interpretation has further broadened the scope and ambit of Article 21 and now right to life includes the right to livelihood. Further, even the right to earn livelihood is also considered as a part of the right to life under Article 21 of the Constitution. This broad interpretation of the right to life is very helpful in checking all such government actions which has an environmental impact that threatens the existence of the poor dislocated from their place of living or otherwise deprives them of their livelihood. Article 32. Remedies for enforcement of rights conferred by this part. Under this article, Supreme Court shall have the power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part. Article 226, Power of High Courts to issue certain writs. Under this article, every High Court shall have the power throughout the territories in relation to which it exercises jurisdiction to issue orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari or any of them for the enforcement of any of the rights conferred by Part 3 and for any other purpose. Article 253 and environmental legislation. The 42nd Amendment also expanded the list of concurrent powers in the Constitution. The amendment introduced a new entry: population control and family planning, forests and protection of wild animals and birds were moved from the state list to the concurrent list. Article 253 of the Constitution empowers Parliament to make laws implementing India's international obligations as well as any decision made at an international conference, association or other body. The Constitution of India, 42nd Amendment Act 1976. Originally, the Indian Constitution of 1950 did not have specific mention of environment protection. But taking note of the Stockholm Conference and the growing awareness for environmental pollution and eco imbalances, the Indian Parliament passed a historic amendment, 42nd Constitutional Amendment Act 1976. This 42nd Amendment incorporated two significant articles, Article 48A and 51A Clause G, to protect and improve the environment. Article 48A says, the state shall endeavour to protect and improve the environment and to safeguard the forests and wildlife of the country. Article 51A Clause G says, it shall be a duty of every citizen of India to protect and improve the natural environment, including forests, lakes and wildlife, and to have compassion for living creatures. Thus, various entries of State List 2 were transferred to List 3, concurrent list, which empower the Parliament to legislate on environmental issues such as forests, wildlife, population control, family planning. It was necessary to make such changes to bring uniformity in environmental law throughout the country. Environmental protection and improvement were unequivocally incorporated into the Constitution by the 42nd Amendment Act of 1976. The Directive Principles of State Policy. The Directive Principles of State Policy are directions that guide the government. Even though unenforceable by a court, the Directive Principles are increasingly being cited by judges as equivalent to the fundamental rights. In several environmental cases, the courts have been guided by the language of Article 48A. Public Interest Litigation, PIL, meaning and introduction. According to Black's Law Dictionary, public interest litigation means a legal action initiated in a court of law for the enforcement of public interest or general interest in which the public or class of the community have pecuniary interest or some interest by which their legal rights or liabilities are affected. Though India's higher courts and in particular the Supreme Court have often been sensitive to the harsh social realities and have on several occasions provided relief to the oppressed, the poor do not have the capacity to represent themselves or take advantage of progressive legislations. In 1982, the Supreme Court approved that unusual measures were necessary to enable people the full realization of not merely their civil and political rights, but the enjoyment of economic, social and cultural rights. This was voiced in its far-reaching decision in the case of People's Union for Democratic Rights versus Union of India. It recognized that a third party could directly submit petition, whether through a letter or other means, to the court and seek its intervention in a matter where another party's fundamental rights were being violated. In this case, the Supreme Court noted the rule of law does not mean that the protection of the law must be available only to a fortunate few, so that the law should be allowed to be exploited by the vested interests for protecting and upholding the status quo under the guise of enforcement of their civil and political rights. The poor too have civil and political rights, and the rule of law is equally applicable to them also, though today it may exist only on paper and not in total. Thus, the court was willing to acknowledge that it had a mandate to advance the rights of the disadvantaged and poor, though this might be at the behest of individuals or groups who themselves have claimed no disability. Such litigation, termed public interest litigation or social action litigation by its foremost advocate, Professor Upendra Bakshi, has given the court epistolary jurisdiction. The court now permits public interest litigation or social interest litigation at the instance of public spirited citizens for the enforcement of constitutional and legal rights of any person or group of persons who, because of their socially or economically disadvantaged position, are unable to approach the court for relief. Public interest litigation is a part of the remedial process of participative justice. In the judge's transfer case, the court held that public interest litigation can be filed by any member of the public having sufficient interest for public injury arising from violation of legal rights so as to get judicial redress. This is absolutely necessary for maintaining rule of law and maintaining the balance between law and justice. It is a settled law that when a person approaches the court of equity in exercise of extraordinary jurisdiction, he should do so not only with clean hands, but with clean mind, heart and objectives. In Shriram Food and Fertilizer case, the Supreme Court of India, through a public interest litigation, directed the company manufacturing hazardous and lethal chemical gases was directed to take all necessary measures before reopening the plant to avoid or prevent danger to life and health of the workers. In MC Mehta versus Union of India, a public interest litigation was brought against pollution of the Ganga water to prevent any further pollution. The Supreme Court held that the petitioner, although not a owner or a party to the case, is entitled to move the court to enforce statutory provisions as he is the person interested in protecting the lives of the people who use river Ganga's water. In Parmanand Kataria versus Union of India, the Supreme Court held in the public interest litigation filed by a human rights activist fighting for general public interest that it is the paramount obligation of every member of the medical profession to give medical aid to every injured citizen as soon as possible without waiting for any procedural formalities. In the case of Indian Council for Environment Legal Action versus Union of India, a public interest litigation was filed by a registered voluntary organization regarding economic degradation in the coastal area. The Supreme Court issued appropriate orders and directions for enforcing the laws necessary to protect the coastal ecosystem. The role of judicial activism in environmental law is paramount, and now one can simply approach the court to have fundamental rights enforced by writing a letter or mailing a postcard to a judge. Such letters based on true facts will be converted into writ petitions. By relaxing the scope of public interest litigation, the court has brought legal aid to millions of Indians in the simplest manner, paving a way towards complacent judicial activism in environmental and other matters. Dear viewers, I hope this session was informative. In the next coming sessions on environmental law, we will be dealing with the international regime of environmental law and various other environmental laws which are specific in nature relating to the environmental problems concerned. Thank you.